Madam Acting Deputy President, I am seeking the support of the Senate tonight to send a reference to the Legal and Constitutional Affairs References Committee to inquire into the government's response to the High Court ruling on immigration detention.
Before you continue, Senator Patterson, could I just ask you to move the motion?
Oh, sorry. Thank you, Madam Acting Deputy President, and I move the motion.
Standing in your name. Thank you.
Thank you. Let's remember how we got here. It's exactly 3 weeks ago today that the High Court handed down its decision. On the next day, the government told us that the individual in the court decision, the applicant NZYQ, would be released, but when asked about the potential release of any other individuals, Minister Watt said, "We are not a government that acts on decisions that haven't had reasons released." It only took until Friday that week that we found out, contrary to Minister Watt's evidence, that the Albanese government was immediately releasing a large number of high-risk individuals from immigration detention following the High Court's decision into the community. This is a cohort who we now know includes rapists, murderers, pedophiles and even contract killers. The following Monday, the Immigration Minister, Mr Giles, told us that 80 individuals had been released and were subject to a range of strict, mandatory visa conditions. It only took 2 days after that Senator Wong admitted that the consequences for breaching these supposedly strict, mandatory visa conditions was ultimately unenforceable because breaching a visa requires that an individual be detained pending their deportation, which the High Court had just ruled was not applicable for this cohort. After continued calls from the Coalition to take action to keep Australians safe, the government finally introduced a bill on Thursday of the last sitting week. Despite giving the Coalition less than 2 hours' notice to consider the bill before its introduction, we identified a number of weaknesses and deficiencies and proposed 6 amendments to significantly strengthen the amendments. Initially, the government said the bill went as far as it could, but subsequently conceded that we were right and those amended measures were necessary, but sadly even managed to botch that as well, because this week we are now considering a further urgent patch-up job to fix the drafting errors from that legislation. Since then, we've also learned that the government has released now 141 high-risk individuals into the community and presumably counting. And just when you thought that this story could not get any worse, we've heard reports that one of the detainees was released into the community without an electronic ankle bracelet, that is, someone who is by definition a risk to the community, and was uncontactable by the Border Force or the Federal Police for a number of days. In breaking news this evening, I understand that person has now been identified because the Prime Minister's office is furiously briefing the media that they have been found and they are now compliant with their visa conditions. That's interesting because it was only 4 hours ago in this chamber when asked, Senator Wong said we couldn't talk about operational matters. It seems with this government that we talk about operational matters when it's convenient and suitable to their political purposes, but not when it's inconvenient. It is pleasing, though, that that person has been identified and is now compliant with their conditions, but many other questions arise from this person's release into the community without an electronic tracking bracelet. Why was it that this person was released without monitoring? Was it because they were asked to wear a bracelet and they refused? Or was it because, as The Guardian has reported today, they were never informed of the visa conditions that applied to them and in fact released into the community without even attempting to put an electronic tracking bracelet on them? Yesterday, the High Court handed down its reasons for its decision, and 2 things became immediately clear. The first is that it was a narrow ruling that relates specifically to the case of the plaintiff, NZYQ. The Court is very clear throughout the judgment that its decision in this case turned on 2 key facts. One, that NZYQ is a child sex offender, and Australia has never before successfully resettled a child sex offender in a third country. Therefore, his detention constituted indefinite detention, and that was beyond the power of a minister to impose. Secondly, they made it clear that it was the admission of this government that resettlement was not a realistic prospect for this person that they determined that his detention was indefinite. Questions now do need to be asked whether or not any others among that cohort of 141 people meet this same standard of no reasonable prospect of being resettled in a third country. Because while this cohort does include many serious criminal offenders, as we've all discussed, it also includes people who have breached the character provisions of the Migration Act and have not been charged or convicted with any offence in Australia. Is the government seriously arguing that the prospects of these people being resettled in a third country is equally as hopeless as a convicted child sex offender? And ultimately we will know when the government attempts to deport any of these people and to re-detain them in the process, because the court has also made clear that it is in fact possible, if resettlement becomes an option, for these people to be re-detained pending their deportation. The other significant finding of the court in its reasons is the court's endorsement of the coalition's approach to managing the risk that these detainees released into the community pose. 3 weeks ago, when first interviewed about this topic, I urged the government to look at the high-risk terrorist offenders framework. I said that the control orders, the extended supervision orders, the preventative detention orders and the continuing detention orders were a possible solution to this problem. In response, the government said we could not possibly legislate such a scheme until the High Court had handed down its reasons, because we don't know whether such a scheme would be lawful or not. Well, now we have the benefit of the High Court's ruling, and it is clear. In fact, it's so clear that the High Court has almost put it up in lights. They've given us a green light to legislate a new scheme based on the risk to the community to continually or preventively detain someone, such as, in their words, a child sex offender. It turns out this scheme could have been legislated 3 weeks ago, and it would be constitutionally sound in the view of the High Court. But the government wasn't ready to act on that issue then, and sadly they've learned nothing since, because they're still not ready to act now. Despite having warning that this ruling was coming, despite having the free advice from the coalition that they should look at a preventative detention scheme, it appears that no preparatory work was done to draft such legislation, because it hasn't been ready to introduce into the House or the Senate today. The coalition has offered bipartisan support to facilitate the passage of such a scheme. We have said we will sit as late as we need to. We have said we will sit as long as we need to. We have said we should not leave Canberra this week without having this issue dealt with, and we expect the government to bring this matter to the parliament as soon as possible. This is the definition of a matter that should be referred to a committee of the parliament. This is exactly the scrutiny function that parliaments are supposed to apply to the executive government of this country. And I particularly appeal to those on the crossbench to support this inquiry. Of course, I'm hopeful that the government will consider the merits of inquiring into this matter. I'm sure, if they are confident about their handling of this matter, that they will think that there's nothing for them to hide, that they will be able to vote for this motion in confidence that it will exonerate their performance in their handling of this issue. But I do have a sneaking suspicion that the government is not enthusiastic about having its performance in this issue scrutinised. But that shouldn't apply to the crossbench. It shouldn't apply to any independent in this chamber. It certainly shouldn't apply to the Greens, because they should have no interest in defending and protecting and covering up the government's shambolic performance in this issue. And while we may have different views about the policy solutions to this problem, we should all agree that parliamentary scrutiny of this problem is a legitimate issue, and individual senators can pursue their own concerns and their own issues in relation to this inquiry. For example, the Greens have been very critical for a long time about the issue of indefinite detention, and what better way than to have a parliamentary committee examining this issue, and I urge them to consider carefully whether or not they can support this reference. Ultimately, the first and most important responsibility of any government is the protection of the community and the safety of the community. And sadly, it is very clear that the Albanese government has spectacularly bungled the handling of this issue. They were not ready when the High Court issued its ruling. They have not been ready when the High Court handed down the reasons for its decision. They were slow at introducing legislation. It was weak and it had to be strengthened, and they've made those same errors again in considering this issue. These are the sorts of things that Senate committees were established to examine. These are the sorts of questions that we should be able to ask and get answers to. We should be able to call witnesses, including from the community, from refugee advocates on the one hand to the family members of victims of some of those people incarcerated. I have had some contact with one of such families. It's a family of a woman who was murdered by Tony Kelesar. Tony Kelesar is someone who came to our country from Iran on a falsified Canadian passport and was granted a protection visa. He went on to murder his wife. After he murdered her, he butchered her and dipped her body in a vat of acid in an attempt to cover up his crime. And he left her 2 daughters to grow up without their mother. He is one of those people who's been released into the community. He is one of those people who, other than having an ankle bracelet and a curfew applied, has otherwise been free to roam about the community. And his release, after first 22 years in prison for his crimes and then a period in immigration detention, has utterly terrified the family of his victim, and in particular those 2 daughters who had to grow up without their mother, who've spoken very movingly in the media this week about their extreme distress at his release. We need to understand how he was released, why he was released, why controls on people like him were not initially adequate, and why the government wasn't ready to take dangerous people like that off the streets to protect families like this. And I would hope that all senators would agree and could support to an examination of that.
Thank you, Senator.